Derek Cosmos, good morning. Okay, I think I am live now on Facebook and YouTube as well. How's everyone doing? Hopefully, you guys can hear and see me better today. I know last week our Wi Fi was kind of crazy. Um, and it looks like I'm a little shaky on Facebook, but if you can see me, let me know. Um, that's the thing about being like in an office building with other offices. You can't just get your own Wi-Fi. Good morning, um, Mel Hub. Salutations, Babatunde. If this is your first time tuning in, my name is Aisha Chidole. I'm an immigration lawyer here in Atlanta, Georgia, but I present clients all over the United States. I help clients with all their immigration matters, family immigration, humanitarian-based cases, removal, marriage, fiancé visa, consular processing, appeals, all of the following. If you want to schedule a call us at 407-995-6567. Guys, I'm very low energy today. Oh, and I wanted to give a shout out to someone called Sweet Gucci who bumped into me at the post office last week, who joins my live. So that was nice to see you there. It's always nice to see people who follow me on live. Wait, let me delete this comment. Guys, I'm trying to put in my phone number, and because I'm talking, I'm typing the wrong thing. So just give me a second. I keep typing the wrong thing. What is going on with me today? Clearly, I'm very low energy. I'm doing good. Flower, Your Dreams is asking. Someone says I am blank. I don't know what that means. Does that mean you can't see me? Or you can sense that I have low energy? Which one? Because my energy is very low today. I need some caffeine or something. My kids are back in school from spring break, and usually it's like a cruel shock to the body because of how early we have to get up. Okay, so I put my number in there. Let me just pin it. Okay, Suzanne on Facebook, good morning. Oh, Siobhan, you can see me. Awesome. Chikatania, good morning. Let's see. When will the adjudicative hold be lifted? I don't know the exact date, but hopefully sometime very soon, hopefully in the next couple of weeks, it's my hope. I was just reading something yesterday because I'm always thinking about how we can help and support our clients. And I was just reading on travel.gov, which is the website for those that are consular processing. It's quite frustrating. Let me see if I can open it so I can just kind of go over it, where they go through all the list of different things, where they're telling you, basically that, this country is being included because of a high rate of collecting public assistance. So there's a pause, and then they tell you, they talk about the other proclamation, for certain countries that have the ban, but then they tell you, but then all of that to say, they say, applicants who are subject to this presidential proclamation may still submit visa applications and attend scheduled interviews. Of course, we know that, but it's just annoying, making people go through this process without giving them a date or kind of like a timeline when a decision is going to be made. But, reading it there for themselves, because, some people have asked me, hopefully you can read it yourself on, any of the U.S. Embassy websites for any of those countries. It's just that, they are processing up until they get to decision point. And at decision point, they're going to pause your case, until they lift the hold. Some countries have multiple different things that they have to overcome, especially if you're outside the U.S. So it just really depends. So it's when people ask me those questions, it's really hard to answer without knowing your own specific country. There's so many different things. Like, for instance, Nigeria. Like Nigeria is dealing with the partial ban outside of the U.S. Again, outside of the U.S., they're dealing with the visa bonds, where they are going to post bond if they get approved for a tourist visa of up to $15,000. They're dealing with an adjudicative hold within the U.S. They're also dealing with the pause of the public charge. So, some things overlap other things. So it depends on where you are filing from, to answer questions. Are you filing from outside the US? What kind of benefit are you filing from? Are you filing from inside the US? For those inside the US, what you have is not a ban, you have a pause, which we don't know the exact date that that's going to be lifted. I will say I have been seeing some movement towards a decision, because we've recently started getting like more RFEs for people from these countries where they need additional evidence, which means that they're still processing those cases. But for the ones within the US, they've said in 90 days, we're pausing this for 90 days or in 90 days, we'll give instructions to the officers of how they want them to review it. 90 days is April 1st. So the question now remains whether on April 1st, they will be giving the instructions, or on April 1st, they will already have the instructions and, continue with these cases. So when it does happen, though, I will let you know, but it's really hard to give kind of like an estimate, okay? And, I want to address this because I know one of our clients had a question about this, so I know a lot of people are asking, where people are getting increasingly frustrated when they go and see USCIS case tracker. Where they go on, USCIS case tracker, and they see that these cases are taking a long time, like especially those who have our cases. Guys, that's not within my control or any lawyer's control. We don't control. People are getting frustrated saying, oh my gosh, the processing time is 4 years, it's 46 months. Why does the time keep moving up? Guys, lawyers don't go into USCIS's page and change that. This is not something that we have control over. This is something that USCIS is indicating. One thing I would tell you from my experience is that because that time is published there doesn't necessarily mean that your case will take that long. The reason why they put that there is to reduce the inundation of calls. When you call and call and call and call, and granted, and it's understandable that you're stressed, but also it takes away time from the work that they're doing, right? Because it's a distraction from them being able to work, So, I think that they put that time to reduce that so that they can be productive reviewing those packets, or whatever it is. And, even for them, every day there's a new change. So they have to readjust how they're reviewing those applications based on the new change. But again, it's not within any of us lawyers' control. We don't work for the government. We don't work for the administration. The administration is the one who creates timelines, not us. And a lot of times when they put that timeline there, the idea is that these timelines are aspirational timelines. So when you look on there, you would see it usually would say 80% of cases will be approved by this date. So what does that mean? It means that there are going to be people that were approved earlier and sometimes later, depending on the situation with the case. But it's just kind of like a template of when to disturb USCIS, or when you can say, oh, the case has been progressing over this timeline or whatever it is. So I understand that it's frustrating to a lot of people, but it's not me. I didn't create that. None of us lawyers did. So we're all in this together. If I could approve everybody today, I would approve everybody. Okay. All right. Someone says, good morning. I did VAWA in 2022 and still no updates. Also, I did a renewal for my EAD and travel docs since 2024 and no cards, just an extension notice. So if you did your EAD in 2024, you're probably coming up on the expiration of your 540 days. You might want to reach out, especially if you have a job that is on the line, maybe to see if they can expedite or make a decision on that work permit. If you have a letter from your employer saying that they will terminate you by X date, or potentially, you facing financial hardship if you're unable to work. There's no guarantee, but it's certainly a try, to see if that will get them to, make that decision. Fred Osobal, thank you for the information. Oh, thank you so much. Thank you. You're welcome. Can you travel overseas with the dismissed misdemeanor charge that was dismissed before I got the green card? Honestly, I know it sucks, but in this administration, without seeing what exactly the misdemeanor is, I would say no. I would need to see it personally. I'm a little bit worried. It's been more than 3 months of filing no notice of action yet. Is that normal? How long must one wait? Again, I don't know what kind of case you have, so I really can't answer that question from a timeline. Have you received a receipt notice, or you're referring to your receipt notice? So it just depends on what you're referring to. Green card holders, I-130 for a spouse, how many years is it taking? The answer to this is going to depend on whether you're in the United States or outside the United States. The visa bulletin for March, which I pulled up yesterday, let me just pull it up again. Right now, they are processing cases from 2024, but if you are in the United States and you are in status, meaning you've not worked under the table, you've not overstayed your visa, and your receipt notice is before February 22nd, 2026, you can file your adjustment of status. That way at least you can get your work permit and travel permit and social security number while you're waiting. So it may take you a little longer. It may take you about 2 years, but at least, you'll get your work permit and travel permit. But the only way that you can do that while you're in the United States is you must be in status. When you're married to an LPR, they don't forgive overstays. You must be in status. You can't have worked under the table. You can't have violated any terms of your immigration petition. The only time that there's an exception, because with every law or rule, there's an exception to everything. The only exception for that is if you're eligible for VAWA based on being married to an LPR, which is a green card holder. If you're married to a green card holder and you're eligible for VAWA, and you file for VAWA, even if you've overstayed your status or you worked under the table, as long as that VAWA I-360 receipt is before February 22nd, 2026, you should be able to file for your adjustment of status. That's your green card application, your work permit, travel permit, and request a social security number. Okay. Guys, when I tell you I'm so low energy, I am struggling to talk, and I have a very long day today. I filled out my immigration documents, but need someone to review it. Will you be able to review my document before I submit? No, we don't review packets that people prepare themselves. It's a liability issue. When people hire us, they're hiring us from end to end to prepare their application and to advise and give them a checklist of what is needed, strategically review and make changes. But we basically are not going to. We back up what we advise, which is why we list our names there as preparers, because we know what we're doing. I personally don't think it's a good idea in this administration, to be trying to do your dibble dabble, and just find, a random lawyer that's going to be like, all right, let me just review it, but I'm not going to put my name on it so that there's no liability to me. But, we're all entitled to do whatever is important to us, but we will generally not review DIY cases. Can you apply for citizenship if your country is amongst the banned country? Citizenship where? Because it's not banned in the US. So if you're in the US, there's no ban in the US. There's an adjudicative hold. So, I think given a country will be helpful. If you're in the US, you can apply for citizenship. The decision would probably not be made till they lift the hold, but you can apply. Is Jamaica one of the countries on the adjudicative hold list? No, Jamaica is not on the adjudicative hold list here in the United States. However, Jamaica is on the 75 country pause outside the United States, meaning if you're outside the United States trying to get an immigrant visa, Jamaica would be one of the countries right now that is on the pause while they're working through the public charge requirements. But if you're inside the United States and you're from Jamaica, you're not subject to any kind of hold. You can, meaning they will process your case and make a decision. right away once you're eligible for them to make a decision. The countries in the US that are under the adjudicative hold, they'll process your case up until the point of decision, and then they'll wait until they lift the hold, which we're hoping will be in a couple of weeks. If I filed for asylum but got married to a US citizen and changed status and got a green card, but now the asylum was referred to an immigration judge to the court to go to the court, what should be done? You need to go to the court and get that case terminated because you've received your benefit another way, which is through a green card. It's always important for those of you who file asylum to make sure that you're withdrawing that asylum application once you get your green card approved. How does a lawyer help at an interview? That's a really good question. So the help of a lawyer begins before the interview. Many of my clients, who maybe some of them are on live right now, will tell you that, we generally do a comprehensive interview prep. I really, really think that success of the interview begins at the interview prep stage. For a lot of these clients, or for a lot of you guys, you've never been in multiple interviews, so you don't know all the different variations and things that could happen. And, I try to ask very challenging questions, to throw up to my clients so that they will be prepared when officers, because the officers are not going to have any filter. If there's anything that looks wonky, they will ask that. So I want to hear what my clients are saying, how they're answering those questions, making sure that they have the answers to those questions. So it's not on the day of because, a lot of times, I would say that 75% of cases that get denied or get an NOID, it takes place at the interview because of a lack of preparation. So if you are prepared and you've had someone who has been to several interviews, that understands the questions they're going to be asking, that understands what it is they're looking for when they're looking for your forms, and how to connect the dots, and to be like, these are things that you need to work on. These are extra things that you need to bring with you to the interview. This is a way to explain, because the thing about applications is that if I have a question and I cannot see the answer right there on the form, best believe that they'll be asking you that. So we want to practice and understand what your explanation is and make sure that it makes sense, and go over it until it makes sense to be able to answer it properly, because it's not so much as teaching you how to do the interview, but it's preparing you. It's like if you're going for an interview for a job, like going to your friend and saying, okay, let's practice, ask me why I want the job, or why do I want this or want that, but because we know the questions that are asked, we prepare you for it. When we get to the interview, most times there are very few things that we are going to be answering, because we cannot answer the question for you. But my job there is to provide clarity for an officer, or to correct an officer that's misapplying law. I remember once, for instance, I'll give you two examples. And if I wasn't there, my clients would have been denied. I had the one client who she actually self-prepared a joint filing for her I-751. And, she and her husband were divorced by the time her interview was scheduled. He was abusive. So we put together an amendment, like a whole packet. We got a psychological evaluation, everything else. She literally hired us like 2 weeks before the interview. And then, we went to the interview. And when we got to the interview, the officer was like, nope. There's no such thing as an abuse waiver, or blah, 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 that you're not eligible. You're not eligible. We need to cancel the interview, and you need to file for something else, right? If I wasn't there, she would have gotten up and said, okay, and left, because she doesn't know what I said. Officer, I don't agree with you. I don't agree with you. We can amend, here's a policy manual, because sometimes I'll take with me certain things. I'll take the rule with me. And I said, and I remember I said to the officer, can I approach your desk? And like, sure. I said, let's turn to page 3, right? So I turn to page 3 and I say, look on page 3, you have category 1A, 1B, 1C, 1D. That shows there we can amend with the waiver for extreme cruelty. And so the officer was like, well, yeah, but, okay, fine, you can amend, but you need to do a new application. I said, no, we don't need to do a new application. Like, we're not going to do a new application, because she's here for the interview and you can make the decision, and respectfully, let's call a supervisor, So sometimes if I need to call a supervisor, we'll call a supervisor. I'm very respectful, but I'm also very assertive. Like, you're not just going to be like, this is what it is or whatever it is. And, we call the supervisor and the supervisor sees that I'm stewing. And I was just like, I'm sorry, like, this is a misapplication of the law, and thank God I'm here with a client, because I've been to this office. This was actually in the Orlando office. I was like, I have been to this office I don't know how many times, and we have been able to amend it. So even though officers can do things differently, this is literally what the rule says. This is what your policy manual says. So the officer was like, okay, we'll conduct the interview, because at this point we've been going back and forth, let me just go, and, we'll conduct the interview, like the officer needed to take like lunch. Okay, just fill out this extra thing or whatever it is, so it's going to renew form. I said, we'll do it in the waiting room. And I need to give it to an officer. I didn't want to give it to someone, in the front, because I needed to make sure I reached the officer. I said, we'll wait till he's done with lunch and give it to him. Gave it to him, did the interview, and said he would give us a decision. I was like, let's see what he's going to say, because sometimes you never know how an officer. I mean, she ended up getting approved, but all I'm thinking is, if she didn't have me, she would have left thinking she's not eligible, and they would have denied her, right? And this one is a more recent interview that I'm going to tell you guys about. And that's where, you need a lawyer, went to an interview, a marriage-based case, couple didn't live, when we submitted the initial application, couples lived in different states here in Atlanta. They lived in different states. And by the time of the interview, they were living in the same states, and the officer said, you do know that when you're applying for a marriage-based case, you have to have lived in that location for at least 3 months. I was like, since when? Actually, before I said since when, I kind of looked in my face like, what? And she's like, counselor, do you have a problem with what I just said? I said, well, actually, I do. When did the law change? Because that is not the law. She's like, oh, yeah, it is the law. And, if my client is on here, she can probably attest to this as well. I said, well, show me the law, because I haven't seen this change. When did that happen? Because at least at the time of filing, it wasn't the case. And I said, I know that is the case for an N-400, which is a naturalization interview, but it has never been. And I've been to hundreds of interviews, and, I subscribe to ILA. If there is any new law, I am getting it, or whatever it is. And she was like, so I said, but anyway, I don't want to go back and forth with you. If you want to send an RFE about that, I don't have, with that one, I didn't have the exact policy number with me. So I said, send the RFE and we'll respond, because I'm very sure, just like you're very sure, because she couldn't find the policy number either, but by the time, before I got to the office, the officer had called, to say that, oh, my bad, that was a mistake, that you're actually correct. So that is where an attorney can help you, if you have, an officer misapplying the law, because sometimes, we're all humans. Sometimes, you can be in there and the officer, is new or doesn't know all the rules, because guys, immigration is so fast changing, it's so fast changing, or sometimes, people confuse stuff. I've met lawyers, have been doing things for years. Sometimes, someone can come into a consultation with an extremely wonky, very complex case. And I tell them, before I qualify you for something, I need to pull out my rule books. So it is something that can be challenging to learn and stay on top of. But you want to make sure that, you have a lawyer that will assert your right or whatever it is when it comes to that. And, sometimes it's as simple as when I hear my client answering a question that I just want to like slap them in the face, like, what are you saying? Like, I usually will stop the interview and say, I don't think my client understands what you're saying. Can I ask them the question in the correct way? And I think that's also culturally relevant depending on where you're from, because, sometimes, when you represent clients from certain cultures, you begin to really learn how the culture interacts, and all of that stuff. And, some things that an officer may ask, it's very in a very American way that, they may not understand. Like sometimes I might be able to step in and help them that. Okay, so I've just rambled all about that, and my time is almost up. Let me just take one more question, and then a few people keep asking me, is Jamaica on the country with adjudicative hold? No, Jamaica is not on the country. Why are VAWA cases being transferred to another office? This is a very, 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 very good question. The reason why is because Vermont is the only office right now that approves VAWA cases. And that is why VAWA cases take a long time. So regardless of where, with a new filing, regardless of where you submit your application to whatever state, it will eventually be transferred to Vermont, who makes the decision on the case. And when Vermont makes the decision on the VAWA case, and you're ready for it to move to adjustment of status, like meaning you file an adjustment of status application, they will transfer it again to the field office. So like, let's say you live in Florida, and it says everyone that lives in Florida should submit their application to Chicago, right, to get your receipt. So you'll get your receipt from the National Benefits Center, which is a good and a bad thing because they've been making a lot of mistakes. They give you receipts early, but they're making a lot of mistakes. Let's say you send it to the National Benefits Center. It will eventually go from the National Benefits Center and move to Vermont, where they're going to make the decision. And then from Vermont, once they make the VAWA decision, they will then transfer the approval with the 485, like the adjustment of status application, to the local field office in Florida where that person lives, so that they can then either schedule them for an interview or they can make the decision without scheduling them for an interview. So hope that's clear. I have an interview. Let me see what time. I think my interview, I'm going to be at USCIS. I'm not sure if it's tomorrow morning or afternoon. But either way, if it's not, I will be on live at 10 a.m. tomorrow. So if I didn't get your question answered, schedule a consultation, get your own individual questions answered. Otherwise, you can join live tomorrow. And if it's generic, I will try my best to answer. I hope you guys have a great day. Bye.